Good afternoon. Welcome to the Appellate Division First Department. We have over 5 hours of argument time requested, so I ask that you only seek the time you need, not the time you want. We have read all the briefs and the records, and we are familiar with the case. People versus Hunt. Appellant? Respondent? Submitted. Tavares versus K&D Equipment? Submitted. I'm sorry, someone here? Do you want to submit or? Okay, submitted. Shadrasha versus Mika is submitted. Arenson versus Prager, appellant? Appellant. How much time are you requesting? How much time are you requesting? Respondent? 6, 1, and 6. Coal Capital versus Automaton. Appellant? Respondent? Is there no respondent? Do you wish to submit without the respondent here? Okay, submitted. Duel versus Duel? Respondent? 10 minutes, please. 6, 1, and 6, and I will be recused on that matter. Paretta versus New York City Transit Authority? Appellant? 5 and 3, please. Respondent?
6 minutes.
5, 2, and 6. Hudson Excess versus certain underwriters. Appellant? Respondent?
5 minutes, Your Honor.
4, 2, and 5. People versus Longo is submitted. Muniak versus KH48. No one's here on that one? Okay, submitted. Noto versus Plank, appellant?
5-2.
Respondent?
5.
5, 2, and 5. Bacharach versus Board of Managers, appellant?
6 and 2.
Respondent?
Respondent
6, 1, and 6. People versus Govan? Respondent?
Respondent requests 4, Your Honor.
4, 2, and 4. And Ghostwet versus GRA Legal is submitted. So the first case on the calendar is Arenson versus Prager.
Good afternoon, Your Honors. May it please the court, Howard Felcher for appellate defendant. I'd like to address with the court 2 specific and distinct issues today. The first is an account stated viable when it's simultaneously commenced with a breach of contract cause of action.
Counsel, we do that all the time. We have account stated and breach of contract, and often the account stated is granted without ever reaching the breach of contract since it's a different cause of action.
But the court, this court, in 3 distinct cases, Dubinsky, Servant, and as recently as Van Poy, said you do not, respectfully. You said we
Said
must
what? I'm sorry, I'm having trouble
You must dismiss the account stated as duplicative of the breach of contract. And those were the 3 cited cases. The one you were on, respectfully, Your Honor, Unisol, which was in 2020.
I can't believe I ever held that, because that goes.
I can't hear.
I said, I can't believe I would have ever held that. I will look, but that goes, it's
But the-
contrary to what I've done
and Judge-
My
hundreds
guess-
of times.
And
Yeah,
my
it was
guess is that that occurs where we've granted the
can
claim as to, on the contract issue, and then we dismiss the account stated claim.
If I'm not mistaken, because I have.
But that we certainly permit pleading of both. I mean,
In that
pleading in the
case-
alternative is sort of basic to our.
In that case, Your Honor, you were both on the same case, indicated that an account stated was independent of a breach of contract, but
It is independent, which is why you can sometimes get summary judgment on accounts stated without reaching.
But the 3
breach of
cases I
contract.
just cited said opposite, and they were after. Van Poy, which you were on, Dubinsky, and also Servant, which Judge Mendez, you were on. And in each one, it said that an account stated is duplicative of a breach of contract and must, I said should to be artful, must be dismissed.
But in those cases, didn't we grant the motion, the contract claim?
No. In those cases, Your Honor, well, there was no, if in fact I'm mistaken, there was no contract here for summary judgment. In the case before you, sub judice, the only summary judgment was on the account stated. And as Judge Mendez said, in Servant, we don't do it. And as you said respectfully, in Vanpoy, you said we do not allow account stated to be used simply as an alternative measure for collection on a breach of contract. Words better than I could have said. And I knew you wrote it by the word simply, being in front of you when you were on the trial bench. So the prevailing law, respectfully, is that an account stated may not be viable and maintained when you simultaneously commence for breach of contract. And in this case, the movant did not move for summary judgment on a breach of contract. They only moved on summary judgment. Now, and on top of that, not only was the defendant's cross motion to dismiss it denied, but the court compounded the summary judgment on the account stated by giving a monetary award. Let's assume that the case law did not exist, which it does, all three.
I can't imagine it does, but I will look.
I wouldn't
Contrary to my whole understanding
I
of
wouldn't
account
stand in front of
stated.
you if I don't have those three. And in fact, Judge Mendez will tell you he ruled in Servant exactly.
Besides Dubinsky, what were the other two?
Pardon me, Your Honor?
What were the other two besides
It's
Dubinsky?
Dubinsky. Would you like the cites? I can give you them.
No, I don't need the cites. I
Dubinsky
have your
versus
brief in
Levine,
front of me. I
Servant
want to know
versus
the
Grage.
names.
Yours was Van Poy Corp versus Solel.
That you didn't cite?
Yes,
in your-
VA. It was you, Judge Gesmer, and you said.
No, in your brief. I don't see it in your table of authorities.
It is. It was cited in the original and it was cited in the reply. Well,
What's the name again?
Van Poy.
I-
And you decided it in 2022.
Okay, I don't see it in
If I
your
may,
table of
I may
authorities.
continue, but assuming
ahead,
that
Counsel.
law was not in existence, but it is, and you and I won't go back and forth. It was also done on summary judgment. There were triable issues of fact. My client said he made objections.
Counsel, the only objection, that means you have 2 minutes left. The only objection that I could see in the record was the objection as to that the bills were too expensive.
I'm going to draw your attention to something more probative. Plaintiff's reply to counterclaim. He states, and verified, so it's the same as an affidavit or testimony, you know that. From time to time, throughout plaintiff representation of defendant, plaintiff would offer, defendant would accept, or defendant would request and plaintiff would agree to adjustments. They used request as an artful term. Defendant objected, and what they did is, because he objected, they reduced the bill.
Which is
How
why
was
the
the-
early, I'm sorry, go ahead.
I'm sorry, you
No,
go
go ahead.
How were those objections noted?
By virtue of, well, orally, but also now I can show you it was said in a reply by, verified reply by the plaintiff themselves. As they put in their action, they said, in fact, throughout their papers, they say, defendant objected because it was costing too much. Now, I can understand that, but what,
Well, indicating that something is getting expensive is not necessarily an objection. An objection is seeing the bill and saying, I object, this is, in these areas, the cost is not accurate.
well,
There's
then
nothing to that effect in the record.
I'd ask the court to juxtaposition that argument with their verified statement. Defendant would request and plaintiff would agree to adjustments to the amounts for the services rendered. Living not in a vacuum, no one just says, oh, do me a favor, reduce the bill. It's because they had a dispute. He requested it. He said there's a problem with the bill. They say he requested it. I don't, he didn't. So we have, but then the last point, I know I have limited time. The last point, the counterclaim was dismissed on the pleading stage for an accorded satisfaction. Now, there's been no decision rendered by the lower court.
You know what, I'm going to let you address that on your rebuttal, since you have rebuttal time, okay?
I'm
I'm going to
getting
let
too
you
old. I can't-
address that on your rebuttal time, since you have time for rebuttal.
Thank you. Thanks for your attention, Your Honors.
May it please the court. My name is Alan Mayevsky. I'm from the firm of Arenson, Mayevsky and Sloan. We are one of the plaintiffs and,
So, counsel, what is the law on account stated? Did we hold that?
well, the statement of the law is incorrect by appellant. I think you got it right. case that, the Unisol case states it quite clearly. An account-stated claim is independent of a contract claim. There's no question about that. The other cases that are cited, in particular the Supergrant case, that case specifically says that an account stated was not pleaded. That's what it says. That's what that case holds. It doesn't hold that you can't have an account stated and also a contract claim, because every
Are there
account stated is
cases-
based on a contract claim.
Are there cases such as opposing counsel stated which hold that an account stated should be dismissed as duplicative of a breach of contract claim?
Only when the account stated is not pled to be where invoices are sent and there is no objection to the invoices, as is here, and so that basically the person who's the debtor has not objected.
Was there an issue of fact about it, objection?
What's that?
Was there an issue of fact about whether the defendant objected?
There is no issue of fact here as to an objection, because if you look at the papers here, the only thing that is ever raised is in the pleadings. In a very general sense, the appellant has never at any point said there was anything wrong with the bill, that you didn't do what you said you did. In fact, he wanted our firm to stay on as counsel. He wanted both firms to stay on as
Is it
counsel.
enough to say that the bills are too expensive or are getting too expensive?
Well, he did say it was costing a lot of money.
And is that enough to raise an issue of fact as to?
No, it is not. And in fact, the cases will say that, and we cite them case after case. If the law is as appellant says, it would wipe out a whole litany of cases in which account stated are granted by this court. And I can give you a list of them.
Counsel,
and they're
before
cited
you
in our
do that,
brief.
Counsel, before you give us the list that you've cited to, before you give the list that you've cited to, what do you make of your adversary's argument that the request for adjustments and all of those on many bills rise to the level of an objection?
This was a 4-year relationship in a very, very hotly contested case. And we had a very good relationship, or Mr. Arenson, who was handling it, had a very good relationship with the appellant. And throughout recognized, you know, this is costing him a lot of money. It's not because we did anything wrong and not because the bills aren't what they said, but, you know, it is costing him a lot of money, and so we'll try to work with you. And throughout the case, he made accommodations. There was never one showing, never one thing in the papers. You don't see it in any of their papers where at any time he said, oh, by the way, how did you do this? This bill is wrong. You did this poorly. In fact, the results that he was getting were results that he really liked. He wanted us to stay on, and we did. And at the end, there is his email, which is really the key on that particular point, Justice Michael, where he says, if I make this last adjusted payment, that will resolve, an appellant said this, if I make that last adjusted payment, that will resolve all bills through September 2022. He says that.
Right, so that kills the counterclaim?
What's that?
Does that
That goes
mean-
to the counterclaim where they try to undo all of the bills that were paid or that there were payments made against. The account stated goes to the subsequent work done where basically appellant decided, I'm going to stop paying. This is, you know, basically this is expensive, but I'm just going to decide at the end of the case how much I'm going to pay. And none of this is disputed.
Right.
So that
The discounts that you gave to him amounted to $192,000, right?
I'm sorry,
The discounts in the bills,
192,000 over a period of 4 years of work. So it was various amounts over that time, and we have an accounting of it in the record as well that you can see. But there is case after case on accounts stated, as I began to say before. Not only is it the Kidrod case, there is the Zanani case, of this court, the Barton case of this court, Minson Gold of this court, all of these are cited in our brief. Lapidus case, the Marcus Company case, all of these are account-stated cases in which, in situations just like this, where the only objection that's raised is raised late and pretty much during the litigation in a very general way, as this was done right here. The only thing cited here is to appellant's own pleadings, where he even then does not say, here is the specific bill that I thought was wrong. Here is the conversation I had with Mr. Arenson, that I told him, you guys didn't do this. That never happened, which is why it's not in the papers.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors. Van Poy.
Counsel, on Dubinsky, isn't that quite distinguishable since the cause of action for breach of contract was moot, since defendant had paid plaintiff the amount he sought,
In
which would
Dubinsky-
also apply to the, excuse me, which would,
Right before the-
excuse me, which would also apply to the account-stated claim if payment was made in full. It seems to me that.
Respectfully, Your Honor, there's an error there. Right
sorry?
before, there's an error. The word before the dismissal of the contract, and I'm doing this by memory, is the word further. Let me tell you what, I have Dubinsky right in front of me, and that's why I'm aware of it.
So do I.
It said, the parties had a retainer agreement. Accordingly, plaintiff's cause of action for account stated and unjust enrichment are duplicative.
I'm looking at the next sentence, which points out that the breach of contract claim was moot because it had been paid in full. So it's irrelevant. I mean, that's a very different situation from this situation, isn't it?
No, respectfully, because the word further, look what it said, further.
I see the word further.
That means-
Substantively, it's distinguishable from this case, isn't it? In that case, the party had been
case-
paid in full. Your client has not paid in full, right?
But then how do we reconcile, respectfully, the preceding where it says a retainer agreement account stated cannot be maintained together? Isn't that what I'm arguing here?
You haven't answered my question about how that's distinguishable.
I
I
respectfully,
don't get to have to answer yours.
I apologize. I always will apologize.
Any further questions?
I don't agree with the court respectfully. I think they were two separate. I think the word further means in addition to. In addition to finding that you can't maintain both. Furthermore, it's rendered moot because the breach of contract was paid.
Thank you.
Your Honor, there
Thank
was...
you. No, your time's up now. Thank you.
Oh, thank you for your time.
Cole Capital versus Automaton. There was some confusion about the calendar call in this case, but I'm going to give you 5 and 1 and 5.
Thank you. Good afternoon, Your Honors. My name is Jeffrey Chubak of the firm Amini LLC. I represent Automaton, a Delaware corporation. This appeal concerns a sale agreement governing the sale of restricted shares that were held by an ex-employee to respondents. All parties agreed that that a stockholder agreement, which is incorporated into the sale agreement in the first sentence of Section 4F, required that the board approve the subject transaction. The board is referred to as the administrator.
Right. So the additional facts in the third amended complaint were that the plaintiff had reason to think that had happened. Why are those facts not enough to get them over the finish line?
So,
At least for pleading. This is a pleading statute. You've had
understood.
so many motions to dismiss. I wonder when you're going to start litigating this case.
Sure. Delaware law, Title 8, Section 141, is clear that board approval has to come in the form of either resolutions that get adopted by the board or through unanimous written.
This is a pleadings motion, so don't they just have to have some augury, some indicia that this happened?
As to the facts alleged in the proposed pleading, the third amended complaint, the allegations presume approval by the CEO, Spencer Hewitt, based on his signing the sale agreement. But it also...
But counsel, isn't there much more? There's an allegation that you had expressly represented, that he had authority to bind the company, that all the condition precedents to transfer were met, and that he and Mogul were the only board members, and that they were both copied on all the emails and involved in the negotiations of the sales agreement. So there's a lot of allegations here that support
The allegation is made
approval.
that Spencer Hewitt approved the transaction, and in the prior motion sequence, the court held that his signature on the sale agreement wasn't enough to waive the requirements as to board approval in the stockholder agreement. But
Right,
turning-
but weren't there a lot more allegations in
Yeah.
this amended complaint than there were in the prior ones to support the
turning to-
plaintiff's
yeah,
allegations?
I mean, the decision turned on the motion court's determination that a majority of the board approved the shares. It really turns on the allegations that relate to Eric Mogul, the other director. And as to him, the subject pleading alleges on information and belief that he participated in the sale agreements negotiation and so should be presumed to have approved the subject transaction. But it doesn't state the basis for that belief, except to point to
What
exhibit.
about all the things I just stated to you, though, which were numerous allegations? Why aren't those a basis? Why aren't those sufficient?
Well, the determination as to board approval hinges on Eric Mogul's the board's formal approval, which requires both Spencer Hewitt's and Eric Mogul's formal approval. Spencer Hewitt's signature and statements don't bind the board. That was the determination made on the prior motion sequence, wherein Justice Leibovitz concluded that the CEO's signature on the sale agreement was insufficient to waive.
So there's clearly allegations that Mogul knew all about this, did not have any objection, and was on board with this transfer.
There isn't an allegation other than the allegation made on information and belief that he.
Right, but we have affidavits now and emails that have supplemented the original complaint.
But the subject email was actually included in the original complaint. But more to the point, it's from 6 weeks prior to the date of the sale agreement, and he was dropped from the email thread at the end of Exhibit D. The email thread that's referred to concerned a potential transaction under which Automaton was going to buy the shares. That was the context in which he was copied. As soon as respondents got introduced, he was dropped from the email thread. There's no. Our position is simply that the motion court erred in concluding that the allegations were sufficient to conclude that Mogul approved, let alone formally approved as required.
Counsel,
by Delaware law.
there's a May 18th, 2021 email between Hewitt and Murphy where I think Hewitt represents that the Goodwin firm had approved the transaction, the sale of Murphy's shares. What are we to make of that email?
Respectfully,
Is it irrelevant? You can tell me that.
I mean, Spencer Hewitt's email, just like his signature, cannot bind the board, and the requirements of board approval cannot be waived by Hewitt's signature or his email.
What about the content of the email that their outside counsel had approved the transaction? Does that give rise to some inference that board approval had happened?
There's no allegation. Respectfully, can I finish? Can I finish answering the question?
Sure, it's
Can
fine.
answer the question.
The allegations turn on Eric Mogul's approval, and Eric Mogul's approval aren't adequately pled. We know that Spencer Hewitt signed a consent in the sale agreement, and his emails that don't address Eric Mogul's approval don't affect the outcome.
Thank you.
Good afternoon, Your Honors. Doris Short from Carr and Abramson on behalf of Kali Capital. To answer your questions, we believe that we've alleged enough as to Eric Mogul. We need discovery to find out the answer to the very questions that you seek. In the email that you're citing in March of 2021, Murphy states, "Before I proceed with anything, could you please explain who this third party is and how they seem to be interested in buying my shares at the exact same discount that Eric Mogul presented to me on March 11th. He was involved in the underlying transaction. We have every reason to believe that he continued to be involved. And I just want to clarify one thing. They keep talking about the board, or a majority of the board. First of all, they were supposed to tell us who the board was and never did. But second, that's not actually what their stock plan states. Their stock plan is very clear. 2016 stock plan, it says, under Murphy's, the restricted stock award agreement to Murphy states that in 5.2, vested shares may not be sold without prior consent of the administrator. The 2016 stock plan then states that the administrator is defined as a committee consisting of 2 or more directors. We believed that we had 2 or more directors that
Wouldn't
were
it also
aware-
be the whole board? That's part of the definition as well. I don't have it in front of me, but isn't the definition longer than that?
It is longer than that, and the specific definition is, the stock plan, sorry, I'll back up. Administrator means the board or a committee.
Okay, that's what I thought.
Then it defines committee as 2 or more people. So I think that, I mean, our impression, our client's impression was that 2 people fully aware of and apprised of the transaction, and then the CEO with apparent authority from many, many transactions prior signs it. Section 5A says that the company approves of the transaction. We had every reason to rely on this situation.
Can we turn to the
what about the fraud?
please, go ahead.
No, go ahead. We were about to say the same thing.
The fraud claim, is it independent of the breach of contract claim?
Sure. It's our contention that that Spencer Hewitt, again, the CEO, director, et cetera, made a representation to our client that if they purchased this SB Media note prior to the transaction for the shares, they would actually facilitate that transaction, right? So if we hadn't purchased the SB Media note, then we wouldn't have had the opportunity to buy the shares. That's the promise that we were made.
How is that extraneous, though, to the contract claim? Isn't that the essence of your contract claim, that you will go, and that was a consideration, that in exchange for us getting those notes, you'll facilitate this,
Right, with all
this
due
purchase
respect.
of the stock?
Yeah, well, from our perspective, they involved 2 different parties and 2 different things. And should that have been included in the recitals, perhaps? Yes, but that wasn't the consideration. The consideration for Automaton was the fact that they offered Murphy these shares, they rescinded, and he was going to sue them, right? So they agreed to consent to the transfer agreement so that they got a release from Murphy, right? That's their consideration. Murphy then gives the release to Automaton, and he gets...
Isn't it inherent in the agreement that what they agreed to do in the agreement, according to you, was to facilitate this sale and approve this sale? So how is this fraud claim any different in terms of the relief that's being sought, thereby preventing it from being duplicative?
An answer?
Yeah, the red light is, your time's up.
Again, we perceived it to be 2 separate transactions involving 2 different parties, and we did not believe that, because we had been promised that the SB Media Note transaction, just because it was not specifically mentioned in the agreement for the share sale, was not related.
But they both have to do with the sale of the shares of stock.
Sure, but we had to buy the SB Media Note for a completely unrelated party.
And
right? So how would we intertwine
Claim's not
those 2?
about the SB note. Both of your claims, the fraud and the contract, are about the sale of the shares, right? You're seeking the same relief on both claims.
Well, we're not seeking the same relief. We actually don't know what relief we'll be entitled to if we are to proceed on the fraud claim. That's part of why we're trying to get to discovery so badly, right?
You don't know what relief you're seeking?
No, obviously, we're seeking both contractual relief, but additional relief under the fraud claim. It's not just contractual, and
You don't know what it is that you're seeking that's additional.
I mean, obviously, at this point, we're seeking lots of different damages
So what's the damages you're seeking that are different
that are
on
different
the
from
fraud claim
contractual claim.
than the contract claim?
I mean, I think that,
I mean, that's one of the tests for duplicity. There are different claim damages being sought. So what different damages are you seeking?
I mean, at this point, we're seeking different damages for the misrepresentation against Hewitt, Murphy, and
So
Automaton.
what are those different damages exactly?
I mean, sorry, I don't mean to not be answering. We believe that we're going to be entitled, once discovery shows us exactly what happened here, to different types of damages, and I haven't quantified them yet, so.
With respect to the fraud claim, if we disagree with you and we think it should have been dismissed, that means Mr. Hewitt is also not a proper party, correct?
Mr. Hewitt is inextricably intertwined in all of these transactions, and I guess.
He signed as a corporate officer, so he'd be on the hook for the contract claim?
No, I was about to say, if you were to remove the fraud claim, then yes, Mr. Hewitt would have to be dismissed as well.
Thank you.
Just a couple points, Your Honor, as I only have 1 minute. First, turning back to the May emails, they're in the record. There were exhibits to the complaint. It's at record page 86 to 89, and there's no mention of board approval in there. And further, 97% of the purchase, the complaint actually alleges that 97% of the purchase price that's at issue in this action was paid out after Mr. Hewitt told respondents that the subject transaction was not subject to board approval. So I don't think the determination as to whether the pleadings is sufficient with respect to the contract claim can turn on the May email.
There's a flavor that the plaintiffs felt like that statement, I'm not saying it's true or not, but that statement was just Mr. Hewitt trying to extort more money from them somehow. So, I mean, again, a pleading motion.
Understood, but more to the point, this is a Delaware corporation, and something that's more formal is required here. Unless your honors have any further questions, I see I'm out of time.
Thank you.
Thank you.
Duel versus Duel, and I am recused on this matter.
Okay.
Moment. Ready when you are, counsel.
Thank you, Your Honor. May it please the court, my name is Stephen Malik from Wigan and Dana LLP, and I represent appellant Andrew Duel. Your Honors, this court should reverse the surrogate's grant of summary judgment simply because there were genuine disputes of material facts concerning two issues. First, what happened to $7 million? Now, I understand that they've said that Mr. Duel, all he should have gotten was the buildings, and that Judge Roth in 1998.
The principal was the principal.
It was supposed to get the principal, and in the accounting, in a number of places, including the record, page 741 to 780, and 1537 to 1576 with the first accounting, and the second accounting in the record, 781 to 833, and 1577 to 1630, the $7 million is identified as principal received, and then it just disappears at the end of the second accounting period. What happened to that money? Mr. Duel raised questions, he objected to that, and he was denied his opportunity.
So we're talking about the due from Duel LLC receivable.
Correct, Your Honor.
And Duel LLC was the managing agent of the two buildings in question, is that correct?
Yes, Your Honor.
Okay.
So it's my understanding, Your Honor, I was not involved in the case then. I'd like to say I was a young man then, but I was still probably pretty old back then as well. But, Your Honor, what happened here, just so that we can go back, and I understand this is a long time ago, but on December 5th, 1996, Mrs. Duel, Irene Duel, petitioned the court to split what was known as Trust B into 3 different subtrusts.
Counsel, you can assume that we know that fact if you want to.
So then in 1998, these building, in January of 1998, there were LLCs formed to hold the interests of these 2 buildings that went to Mr. Duel. Then the judge issued the first allocation decision. And so it was the LLC interests that were actually challenged, but they're referred to as buildings 29 and 100. And the question is, what happened to that due from Duel LLC receivable? The second issue that the surrogate erred on was determining...
Let's talk about your opponent's response to that, which is that essentially it was just a bookkeeping matter between the companies because they're all owned by the same people. And so it was just a shuffling around of chimeric liabilities.
Your Honor, that's an after-the-fact explanation from lawyers in a legal brief. There wasn't one witness who was deposed who testified that that was the case. In the record, which we've cited in our brief, Alan Pavel, the accountant who prepared the accounting, said he didn't know. Thea...
Right. Thea said in 2004, she said, if you asked me in 2004, I would have known then.
But I don't know now, so
Right.
There was no information. And I would argue, Your Honor, while it's not really in the briefs, it is a well-established principle that a fiduciary has an obligation to keep records concerning the administration of the trust. The burden was really on Irene to keep records concerning what the receivable was that was in the trust, to maintain those records so it could explain the action. And the absence of those records shouldn't be used to ding Andrew for not being able to explain what happened. It actually should go against Irene. At least the surrogate should have considered those issues at trial. And that's really the issue. This should have gone to trial because, Your Honor, to answer your question, it's a plausible explanation. It was a bookkeeping error. But there are other explanations. And one of them is exactly what Mrs. Duel swore to under oath, that this was principal received. And in the first account.
Swore to under oath in the accountings, you mean?
Yes, Your Honor, you know.
Maybe we should switch, I don't know if anyone has, oh, please.
I have one question. When do you claim that this $7 million went missing?
So, Your Honor, in the accountings, speak.
I understand. Is there a time when you claim it went missing?
So, Your Honor.
I mean, this estate dates initially from 1977. When is it in the last 40, 50 years that you claim this $7 million went missing?
Good question, Your Honor. So, with the respect to the first accounting, okay, and all I can do is point to the accounting, which Mrs. Duel swore was complete and accurate.
I was hoping you could give me a date.
Yeah, so, Your Honor, it's reflected in the first accounting because that's when the trusts were created, was 1998. And the first accounting shows on the record, page 762.
You could just tell us, you don't have to hold it up.
Yeah, no, so it's at the start of the first accounting period, there's due from Duel LLC in one building over $5 million, and in the second building, $3,000. At the end of the accounting period, it shows that there's only $1 million and change due from Duel LLC, and then at the start of the second accounting, it reflects that. And at the end of the second accounting, where it says property on hand, there's zero. So somewhere between 1998 and 2011. And the accounting actually
Why is
shows
it that that issue didn't become ripe for consideration before now?
Your Honor, I can't speak to why the issue wasn't right before now. The accounting wasn't filed until 2012. The objections were filed the amended verified objections were filed in 2020. We had COVID, obviously, 2020, 2021. I don't know. I was not involved in the surrogate court proceedings below.
Counsel, the accounts that you were just holding up for us, does it reflect any change in the principle whatsoever?
It does, Your Honor. It reflects that realized increases in principal. If you look at page 764, for example, it shows that there was an increase in the value from 1997 to 1998 of the due from Duel LLC receivable, and that there was a similar increase on page 765. If I see my time's up.
You have time in rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Peter Gordon from Arnold & Porter on behalf of petitioner, respondent Benjamin Duel. Surrogate Mella, who's been intimately involved in this case for years, went through the voluminous record, the same record that's before you, understood and evaluated all of the issues before you, and got this 100% right. Andrew raises two issues of alleged error on appeal.
Yeah, I mean, Irene knew what principle was, because elsewhere in the accounting she uses that term. So why did she refer to these amounts, the due from the Duel LLC? Why is that referred to as principle in her accountings?
So Irene Duel has been dead since 2014, so I can't give you exactly what was in her head. But what I can tell you is what...
She was deposed or not?
She was not. She died
deposed.
before she was deposed.
Okay, thank you.
But what I can tell you is it's very clear that the buildings were managed until April 1st, 1997 by an entity called MHC, which was managed by Andrew Duel.
Right.
The MHC buildings had a due to from MHC Holdings, which is in the record, of $4.8 million. When the buildings were transferred to Trust B, in accordance with the 1996 decision, it was very clear that only buildings were transferred. But because of the issues with Andrew, a decision was made to keep the schedules the same way that Morgan Holding Corp. Had issued them, including having the $4.8 million as the due to from account. The decision was made to continue that practice that Andrew had done of keeping the book accounts separate from the business account, and then was written off in 2004 as explained by Thea Duel. And so that's why it shows up. But
the due to accounting was something that was started when Andrew Duel was basically managing that company that was managing the building.
Correct. Andrew, for whatever reason, kept the books that way and they continued it. But the point that I think is so salient and the point that the surrogate really focused on is all of this doesn't matter. And why doesn't it matter? It doesn't matter because the record is crystal clear. The record that Andrew himself established that they tell you, ignore, don't look at that record, but it is clear, crystal clear, exactly what assets went into Trust B. Why do we know that? Because in May 1996, the surrogate listed the buildings that went in. We can count them, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So we know exactly what it went in. There's no reference to any additional multi-million-dollar receivable. During the period that that was up on appeal, again, Mrs. Duel came before the court and said, Andrew is so litigious, please separate the subtrust into 3 separate categories. Andrew, at that point, had no income interest, it's undisputed. All he was entitled to was some of the buildings.
But Andrew's expert posits that there are various ways that the principal could be enhanced. And could this be an example of the principal being enhanced?
No, and you know why? Because we know that 2 buildings went into the subtrust and 2 buildings popped out. Andrew Duell's expert, who didn't look at any of the underlying records, doesn't even know whether this could be a principal or an income item. He posits certain counterfactual hypotheticals. Maybe there was a note. Maybe there was a sale. Now on appeal, maybe there's a reserve. We know from the record none of those things happened. It's impossible. That's what the surrogate found. It just can't have happened because we know what Andrew Duell was supposed to get. It's set forth in decision after decision after decision exactly how this was supposed to work. And then we know what came out on the other end. There's no magic alchemist that can turn that into assets where none exist.
We should probably talk about the commissions while you're up there, because he's also claiming he's entitled to commissions.
Sure. So
when did he first demand them? If
it
you
was,
recall?
as Surrogate Mella points out in the decision, the first time Andrew demanded income commissions was in connection with the objections to the accounting, well after all the income had been distributed. And as I'm sure this court knows, pursuant to Surrogates Procedures Act 2309, subsection 4, it's very clear, and I quote, commissions payable from income for any given trust year shall be allowed and retained only from income derived from the trust during the year and shall not be supplied from income on hand in respect of any other trust year. Accordingly, if you don't ask that these be reserved, per the plain language of the statute, it's waived. Andrew says, statute doesn't apply to me. You shouldn't apply it because I was frozen out of certain management decisions. So how can
Did he ever make a demand of his co-trustee?
He never did, and the surrogate, as Mella notes, both at oral argument and his deposition, prior counsel and Andrew conceded that despite the many, many letters, the many, many motions, the many, many briefs, never once did he raise his right to income commissions until after the income had already been distributed.
Any other questions?
Any other further questions?
Thank you, counsel.
Thank you.
Okay, counsel, you've got 1 minute.
Thank you, Your Honor. 3 points, and then I'll sit down. One, with respect to commissions, because that was just addressed. The statute says the trustee is entitled to the commissions. There's nothing in the statute that says a co-trustee has to demand, request, ask, and you're being asked to issue a ruling and to uphold a surrogate where there isn't a single case that's been cited by the surrogate or our adversaries for that position.
What about the statute that requires that the commissions be paid from the income of that year?
It's a great-
for which the commission is being requested?
Great question, Your Honor, and it's really important to understand in the objection, one of the prayers for relief was that the fiduciary who didn't pay the income commission should be church surcharged. And the amount of that surcharge should be determined at trial. Again, remember, this is summary judgment. The court denied Andrew the opportunity. And I would say the second point that I wanted to make, which goes to the commission issue as well, is that what you've heard is a story. It's a plausible story. But there's other explanations as well. And Irene put in her accounting that this was principal. It was principal on hand, received as part of the LLCs for the 2 buildings. And when there's competing stories, the case law is clear that the trial court shouldn't determine credibility on summary judgment. She should have heard the evidence, and she should have heard the witnesses.
Counsel, you make that point fulsomely in your papers.
And-
You want to quickly tell us what the third point is?
And the third point, which I think is really important, is that Duel LLC was formed by Irene in 1998, just before Surrogate Roth issued her decision. There has never been, it's a 2,700-page record. I have it in 5 binders, double, each side of the page to preserve paper. And there's not one sentence before 2012 that deals with this issue of a receivable. It was never brought to the court's attention. It was never litigated. And to hold that Andrew is somehow barred from raising an issue that was never part of the discussion. What was in the trust in 1996 is what was transferred in 1998. And then Irene identified this receivable, and it should have been transferred as well. And Andrew should have had his day in court. Thank you for your consideration, Your Honor.
Thank you both.
Paretta versus New York City Transit Authority.
David Tolchin for the plaintiff appellant. Your Honor, there's a typo on the calendar. It's Paretta with an E.
Paretta, okay.
Our plaintiff was injured because the defendant bus drivers were negligent as a matter of law in the performance of their job duties.
When you made your first motion for summary judgment, what kind of evidence did you present to the court regarding precisely that you are entitled to summary judgment on liability?
Yes, Your Honor. We've been very candid in what evidence was submitted. It was primarily the video of the accident, a couple of reports that were produced from the FOIL, and 58 transcript, notice of claim, and a couple of pictures.
Nonetheless, the court found that there were still issues of fact and denied you summary judgment.
The judge found there was issues of fact and denied summary judgment, and also issues of fact as to the cross motion from the defendants, which was some of those issues were really defendants' issues.
Okay. And how soon after that first motion did you make your second motion?
Like 2 years plus after the first motion, after COVID had resolved, and after we were able to do depositions, and after we were able to get 3 depositions of the defendants and numerous admissions from the driver and other reports and admissions from the drivers that we never had any access to.
So you took a bite at the apple, as we would say. You made your motion for summary judgment. You, according to the court, did not present it with sufficient evidence to establish your entitlement, and your motion was denied.
It was denied. We don't think...
And 2 years later, you then make a second motion, calling it a motion to renew and re-argue?
It was a motion to renew, and not re-argue, motion to renew. We asked, based on the new evidence that we obtained, that we could not have had when we made the motion originally.
So maybe when you made your motion, you didn't have sufficient evidence to have made the motion because you had not even gone through discovery yet. We
hadn't gone through discovery, but not every motion needs to have discovery to win. We could have discovery. We had, if you look at the video, I mean, 9 out of 10 lawyers in this room would make that summary judgment motion based on the video. The judge found there were questions of fact. Whether or not the judge was right, there were questions of fact. There weren't, we didn't have admissions. Now we have all this new evidence, and even if we could have made the motion stronger, we didn't have the ability to get new evidence.
What affirmative steps did you take in order to compel discovery so that you would have this information in a more timely fashion?
You know, we couldn't do anything at all. Nothing at all. We had
no
COVID.
EBTs
we
virtually?
couldn't get EBTs.
You couldn't do that virtually?
We could not. There was no order from the court being issued.
Was there a motion to compel?
There was no permission to grant, no.
But
The
you
court
could have served
did
a
not
notice-
give us
excuse me,
permission to
counsel.
make a, I'm sorry?
So you could have served a notice for deposition
we
without
did.
an order from the court. You don't need to wait for a court order to schedule a deposition.
No, we
do you?
did, and it was ignored. And we had a pre-C order that scheduled depositions, and they didn't go ahead with it. And we waited for the compliance conference in July. This our PC order was in February. We waited till July. We still couldn't get the depositions. And then the court administratively canceled all compliance conference orders. We had no ability to obtain discovery, just like in the cases that are cited in our brief, where a defendant moved for summary judgment before taking the plaintiff's deposition. And then, after taking the plaintiff's deposition, the defendant moved again for renewal. And that was granted. It was perfectly fine because the court said they didn't have the ability to do the plaintiff's deposition before because different reasons. But in our case, we could not obtain an order of the court or any way to compel a deposition of the transit authority. And we needed 3 eventually. So there's no question as to that the securement device for the wheelchair was dangerous. It plainly was. They admit it was dangerous. In fact,
Counsel, when you made your first summary judgment motion, you knew that the driver, Phil White, had not inspected the bus, correct? You knew that when you made
Phil White was there.
No, in other words, but you knew the fact that he hadn't inspected. Part of what you're moving on now, as I understand it, is that there was no inspection by the driver preceding Mr. White and no inspection by Mr. White. But weren't those facts known to you already?
No, we didn't know that. We didn't know that. We have 8 minutes from before the accident when we see that driver White is. You can actually, if you
wasn't he in some? Wasn't that recited? And you also got reports via FOIL. Wasn't that recited in the reports?
No, it was recited in the sense that the claimant or the passenger claims that she fell because it was. We don't have an admission by the defendant. We don't have that until 2 years later when we took their depositions.
Well, there was an accident report that had that indication in it, correct?
Indication? Is that admissible? It's an admission by the defendant. I'm saying rhetorically, how can we, the Judge Adams found that we did not establish as a matter of law that they created this condition or they had notice of the condition. We accepted that. We did more discovery. We found out they actually did have discovery.
When I say indication, it was more from the standpoint of something that would have given you the understanding that you needed to do something in a more timely fashion in order to get that admissible evidence so that your motion would be timely, not that you put an indication before the court as your evidence. That's what the word indication was meant to mean.
Your Honor, I think you're talking about our diligence in not obtaining discovery before we made this motion. I think that's what the court is talking about. But the fact is, no amount of diligence could have obtained the admissions and the depositions at that time. This is a once-in-a-100-year pandemic. When the court system was shut down, they were taking summary judgment motions eventually. They were not taking discovery motions. They were not having compliance conferences.
Thank you very much, counsel.
Okay, thank you.
May it please the court, Tim O'Shaughnessy from the MTA Law Department. The compliance preliminary conference order was February of 2020, and as I'm sure everyone well knows, in March of 2020, the courts shut down, transit shut down. Both of them went to everyone working at home with absolutely no previous plan to work at home. So yes, we didn't provide discovery we were supposed to provide in February, but the reason is obvious. We agree with the plaintiff that the reason is obvious. But the plaintiff, their attorney said in an affirmation below, they thought liability was so clear that they made their motion, all right? They should have waited because we had a once-in-a-100-year pandemic. Did not give them the right to make successive summary judgment motions. And in fact, when where original motion was denied, plaintiff filed a notice of appeal, but did not perfect it, and did not move for re-argument. So now, on the subject of re-argument, on the first motion, they had the video, they had a document, the driver said he had not done an inspection, they had a statement from a supervisor saying that when he got there, the wheelchair restraint was not locked in its proper position. And you know, they also had the 50H transcript of the plaintiff, in which she said that when the driver started walking toward her, he pushed the restraint back in, which, now that I've raised this, plaintiff will argue at trial that that's an admission that it shouldn't have been out. So the only thing that was added on this new motion is the deposition of statement of the driver that it shouldn't be out if there's no wheelchair. But if that's different from what was shown in the first motion, it's not substantial.
I don't think they had the MTA rules and regulations either via FOIL. I think they only got that just through discovery. And that's where the inspection regime is set forth. Maybe that's not relevant because it exceeds what's necessary under the rules of negligence. I don't know. But I mean, they didn't have that either.
They didn't have that.
They didn't have
we do have that crossland problem, but also there's nothing in the rules. It says there has to be an inspection, but that might have been in the statements, or at least implied in the statements that no inspection was done. But there's nothing in the rules that says when you do the inspection, you have to look at the wheelchair restraint on the floor or the other wheelchair restraint and make sure it's in proper condition.
So, counsel, are you conceding that because of the pandemic that discovery was delayed and that was a reason for filing the motion as late as it was?
I will agree that it was, discovery was delayed, but what they should have done is not made the motion. The fact that we had a pandemic did not give them the right to make what are successive summary judgment motions.
But if they are not able to get the discovery in a reasonable amount of time because of the pandemic, and they needed that discovery to make the summary judgment motion.
But this was not a situation where there was a note of issue date coming up, which is what I think it not said in the cases that plaintiff cites, but it was probably what was going on.
This was all pre-discovery. This was all pre-discovery, so there was no discovery completed.
So they should have waited till discovery was completed. Yes. The second issue of fact that the court found the first time was how the wheelchair restraint got in that position. The only thing that plaintiff points to on a new submission is a statement in the bus driver's deposition that generally the bus driver pulls out the wheelchair restraint when a wheelchair customer comes on. But that's only a general statement. We know absolutely nothing about what happened here, and that's not sufficient to get summary judgment. And I should notice also that the bus driver testified at his deposition, which was submitted on the second motion, that when he got on the bus, although he didn't do an inspection, he said he looked back there and didn't see anything out of order. And given that it's plaintiff that's moving for a summary judgment, and every inference is drawn in our favor, the inference can be drawn that it was not in the extended position at that time. The final two issues of fact that the Supreme Court found the first time were whether the condition was inherently dangerous and whether it was readily observable.
Yeah, readily observable, I don't think was a very strong reason to deny summary judgment. Wouldn't you agree that this goes to comparative negligence?
No, I believe that citing the cases we cited in our brief.
Are they all pre-Rodriguez cases?
It's not sufficient for the plaintiff to get summary judgment. But observe, this is a renewal motion. And what plaintiff says in his brief on these points is, oh, that, as Your Honor said, that goes to comparative negligence only and it's not relevant. But that, I think that's not right because of the cases that we cited in our brief. But also, that is a challenge to the prior order.
Yes, that's true.
If they disagreed with that prior order, they should have appealed or moved for re-argument. They cannot at this time challenge the findings of fact on that prior order.
Thank you.
Thank you.
The comparative negligence issue was a summary judgment on the cross motion that the defendants had made. So the court found that there's a question of fact as to whether it was readily observable. But Rodriguez, Tropper, these courts say that there's that it's an issue of comparative negligence, not a reason to deny the plaintiff summary judgment when counsel just stated that plaintiff should have known that it was dangerous sticking out. It was dangerous there. It was a tripping hazard. No one denies that it was a tripping hazard. Why the court below found that there were questions of fact Well, we fleshed those out. We don't have to appeal or re-argue if we think that the court was wrong. We could have waited for trial, but now that we had all this discovery, we moved for summary judgment. Again, renewing the motion for summary judgment. That's the admission by, it wasn't just a general statement that, well, the driver should push it back. This was required by the rules and regulations and the training manual that the driver, and only the driver, would ever touch this securement device. In the 25 years that the driver who testified said only drivers, never seen anyone else ever touch this thing. We've all taken buses. Who's ever thought to touch these little contraptions that come out? You have to somehow push a button and push it in. And if you look for the 10 minutes before the accident, there are a whole bunch of people who come on and off the bus. They're all stepping around it, stumbling over it. The plaintiff doesn't see it, so she falls over it. No one out of all those people ever thought, maybe I'll push it in. It doesn't happen. If there was some other person, like a passenger, who was pushing it in or pulling it out or whatever it was, the transit authority would have taken that video and showed it to the court. In 2 seconds, they would have had it.
Do you have a question?
But
Okay,
anyway.
thank you very much. Your time's up.
Thank you, Your Honors.
Hudson Excess versus certain underwriters.
Good afternoon. May it please the court, Sarah Zolkowski for the defendant appellant certain underwriters. It is respectfully submitted that the lower court erred in granting plaintiff's motion for summary judgment and ruling that plaintiff's policy was excess to the defendant's policy.
Counsel, are there any cases that address this specific policy in this specific language, or is this really a case of?
This is a case of first impression. I have not found any cases in my research which deals with this specific endorsement, which is found in the Hudson Excess policy. As much as Hudson Excess would like you to agree with them and find that they are a true excess policy, there is an endorsement within their policy that makes it primary and non-contributory when they're for an additional insured when required by contract.
How should we address the interplay between the underlying trade contract language and the policy? How does that impact this case?
Well, this endorsement in the Hudson Excess policy does direct your attention back to the contract and does say when required by contract that it will be primary and non-contributory. And the contract at issue, I believe it's on page 383, it does in fact provide that the insurance to be provided to certain underwriters, certain underwriters insureds is to be primary and non-contributory with any other insurance on which the additional insured is a named insured, whether or not such insurance is primary, excess, self-insurance, or insurance on any other basis. So certain underwriters, it's without a doubt, it's undisputed that certain underwriters named insureds are entitled to additional insured coverage under both the First Mercury policy and then also under the Hudson Excess policy. Since the First Mercury policy is providing primary coverage to certain underwriters named insureds, by definition and by the terms of the certain underwriters policy, that policy becomes excess.
Let me ask something. If we didn't, do you concede that if we didn't have the trade language in the trade contract, that if you just looked at the two policies, that you would in fact be primary over?
No, I wouldn't, because I don't. The endorsement at issue does not require that there be other excess policies. It's other excess coverage. And the other excess coverage that is being provided is that by certain underwriters. So if Hudson Excess had wanted to say that it would be excess to other, it would be primary and non-contributory to other excess policies, it could have said so, but it did not. It says it's excess coverage. And since the coverage being provided to the certain underwriters named insureds is excess, by definition, the primary non-contributory endorsement to the Hudson Excess policy comes before certain underwriters policy. I do know that Hudson Excess pointed to the fact that there were issues with respect to that the court should consider the premiums being paid to determine the level of the risk. And I would state to the court that that if you were to look at the premiums here and you divide it up between the the amount of coverage and the years of coverage. In fact, the certain underwriters policy is actually less than the Hudson excess policy. It's $174,000 for 2 years for $2 million worth of coverage, whereas the Hudson excess policy is $101,000 for 1 year of coverage and $5 million. So I don't think you could really look towards the value of the premium in considering this. I think you have to look at the terms of the policies, and when you consider them, the clear language of the endorsement of the Hudson excess policy makes that excess where there's other excess coverage to the additional insured.
Thank you.
Thank you.
Your Honors, may it please the Court, Michael Panayotou, Melito and Adolphson, PC, for Respondent Hudson Excess. The decision and order of the Supreme Court should be affirmed. The Court correctly found that the policy issued by Hudson Excess, which is a true excess policy, was excess over the underwriter's primary policy. Underwriters is seeking to undo New York jurisprudence on priority of coverage and have the Court
Counsel,
declare...
let me go back to the question I asked opposing counsel, which is whether there are any cases which actually address this issue where the insurance policy expressly incorporates the trade subcontract language, and this trade subcontract language arguably makes your client not excess.
Well, I would say that...
Are there any cases that address this particular provision in the Hudson policy and how it should be interpreted?
Sorry, not this endorsement. I would say that...
So this is a case of first impression in terms of deciding that issue? Because you said it's long-established precedent, so that's what I'm trying to...
Well, let me clarify. With respect to the fact that an excess policy is written as such, it's excess over all available primary coverages. To the extent that there's a subcontract or a trade contract that requires a certain type of coverage, that doesn't it doesn't turn the Hudson policy into a primary policy, because the policy terms and conditions are what govern here. The endorsement at issue...
Well, wouldn't both of them be excess in effect? It's only which one is the excess, because we have a primary policy, there's no question, which is the Mercury policy. So it's not whether primary, it's which one should be the excess here.
Well, the underwriter's policy is still a primary policy, Your Honors. It's just a primary policy that is excess over the first Mercury primary policy. If you look at the other insurance language of the underwriter's policy, it states that...
Paragraph 4B.
Sorry?
Paragraph 4B you're about to look at.
Exactly. It says it's primary, but it's excess over any other primary insurance where you, meaning the named insured, have been added as an additional insured. Other primary insurance necessarily means that the underwriter's policy is still...
What do you do with the language about excess insurance, where it's agreed that such insurance as afforded by this policy for the benefit of an additional insured shall be primary to and on a non-contributory basis with any other excess insurance? How are you interpreting that excess insurance?
Well, I should mention that this endorsement is added to the policy. It doesn't replace any language in the policy. So the court needs to look at the whole coverage grant. We discussed it on our brief on page 3 on our opposition brief. The other insurance policy of the other insurance language, of the Hudson policy states that this insurance, meaning the Hudson coverage, is excess over and shall not contribute with any other insurance, whether primary, excess, contingent, or on any other basis.
Yeah, but what are you going to do? What do you do? How do you interpret this language, which definitely has the excess insurance language, that it's going to be primary over any other excess insurance? It doesn't say excess insurance policy. It says excess insurance.
I don't think it needs to say any other excess insurance policy. I think the language is clear that any other excess insurance available to the additional insured.
Should we read excess insurance to be identical to excess policy?
I think that's reasonable, because if the court looks back at the other...
Would it be very easy if you'd have said excess policy if you meant excess policy?
I suppose that could have been done, but I don't think that changes anything, because if the court looks back at the other insurance clause of the certain underwriter's policy, it doesn't say other primary insurance policy. It says other primary insurance. So it's kind of the same thing. It also admits the word policy. So I think the only reasonable interpretation of this language is that the Hudson excess coverage is the first excess coverage to go. If there's any other excess coverage, true excess, again, we're talking about, because again, the Hudson policy is written over the first Mercury policy that's scheduled as the underlying insurance in the deck page versus the underwriter's policy. It's not written over any other coverage. If the underwriter's insurance has,
But why isn't Lloyd's excess insurance as defined in that clause? Because it says it's going to be primary to any other excess insurance. Why isn't the Lloyd's policy excess insurance?
because it's a primary policy that's excess over the first Mercury
It's
policy.
excess. That's just how you just described it as excess insurance.
Well, I'm talking about the priority of coverage with respect to other primary
It's
policies.
excess, isn't it excess though, and that is excess over the primary policy?
Again, Your Honors, I think the case law, Export Rock and Bovis, make it very clear that when a policy is written to be excess coverage, like the Hudson excess policy is, with a different policy scheduled underneath it, that it is an excess policy and the primary policies have to go first before the excess is implicated. I'll happy to answer any other questions. Thank you, Your Honors.
Just real briefly, Your Honors, if in fact there is any sort of ambiguity in this endorsement, and I think it clearly, if there clearly is, I think it has to be construed against the
So
drafter.
why isn't Bovis controlling in this case?
Excuse me?
Why isn't the Bovis case controlling in this case?
Because you don't have this endorsement in the Bovis case. Those are ISO forms that you usually find on any other insurance policy. This is an endorsement specifically written by Hudson Excess, specifically inserted into this policy, modifying the other insurance provision. This has not been considered by any other court, and it's a certain underwriter's position that since its policy is excess by virtue of the fact that the first Mercury policy is primary, that the Hudson Excess policy must come before, because the controlling contract, again, requires that it be primary, non-contributory to any policy provided by these certain underwriters named insureds. No other questions? I'll rest my briefs.
Thank you.
Thank you.
Noto versus Plank?
Good morning, good afternoon, Your Honors. May it please the court, Daniel Kaiser for the appellant. The issue for your consideration on this appeal is whether continued employment can serve as adequate consideration for compensation agreements in the context of the employer-employee relationship. There is a number of cases that have addressed this issue we cite in our brief. The court below ruled that, in fact, it was not adequate consideration, that a plaintiff in my client's position would need to demonstrate that they would have resigned their employment but for this additional compensation that was promised to them.
It seemed to me that the alleged promise for the 75 units also came so quickly after the plaintiff began work. And so that was also, I thought, informing the trial court. I may be mistaken.
No, it did, Your Honor. It came very quickly after. It was an additional compensation promise made by the defendant to my client after the initiation of his employment. And my client, continued to work for years following that equity grant. The court, as I said below, said that wasn't sufficient consideration. As Your Honors know, the law of consideration is very clear. Courts don't get into the business of judging the adequacy or sufficiency of consideration as long as it meets a minimum threshold, and we would submit include.
Counsel, could you address your client's claim for the 3% of the MNI?
Sure, Your Honor.
And whether or not the oral agreement that was made against any,
yes,
would sustain a claim against defendant's patch or MNI?
Yeah, I was actually, Your Honor, in full transparency, a little confused as to how the decision, what was kept in and what wasn't. That claim actually was dismissed against 2 of the corporate defendants, which we do not on this appeal challenge. So that 3%, that second equity grant, remains in the case as to one of the corporate defendants.
Which one?
As to Plank.
Okay, but not as to patch or MNI?
As to Hale. Right.
I'm sorry?
Counsel, thank you, Counsel.
But not as to
My
Patra and
co-counsel
I.
reminded me, it's as to Hale. So, but we're not challenging.
So is the only part of the appeal that you're now pressing forward with is the claim with the 75 equity
It's the
units?
75, yes.
Okay, and so that's the only thing we're now considering on this appeal?
That's correct, Your
And the
Honor.
rest of it's withdrawn?
Right, that's right. And my initial moving brief was not clear on that point, and I apologize.
You're now withdrawing that portion?
I apologize to Your Honor. Yes, I would only suggest though that the consideration legal decision of the lower court could potentially become applicable to that 3% equity grant if depending on how what legal standard for consideration is developed by the court. But bottom line is, and then I think I'll sit down, Your Honor, is that consideration, courts don't get into the business of looking at its sufficiency, certainly not on a pleadings motion. Remember, this is at the pleading stage. It's not even at the summary judgment stage. And that, in fact, consideration, continued employment is, in fact, adequate consideration. And I would just end with, if I'm working somewhere and I get promised a bonus, a year-end bonus, and I get to the end of the year, I've earned that year-end bonus. And certainly an employer can't come back to me. The rejoinder couldn't be, well, I'm not sure you would have resigned but for that additional consideration. So, I think you would have stayed here anyway. That's not the rule in New York. It can't be the rule in New York. You stay in work, you get what you were promised. That's not more complicated than that. And that's all I have for you, Your Honor.
Thank you.
Good afternoon, Your Honors. Judd Burstein for the respondent. This is one of those cases where there's law from this case directly on point, which is it's in Apostolos, and then it's also in, it's not Apostolos, I apologize. It's in Taylor v. Blaylock, and then Tierney v. Capricorn. And what this court described in Tierney v. Capricorn, it said, in describing it, we held that in claiming the additional bonus, the employee purported to do no more than he was already obliged to do under the written contract.
But is an at-will employee required to stay in his employment? I mean, why is he required under his contract, since it's an at-will contract, to remain in his employment? So why, I'm not sure why that isn't adequate consideration.
Well, it's not additional contribution because he signed an agreement which said, I am going to do X, Y, and Z. He's
saying the consideration is, I agreed, I could have left any time, it's an at-will employment, I don't have an obligation to stay, and I only stayed in this employment and didn't quit and go somewhere else for a better opportunity because this promise was made to me for this additional compensation.
Well, I do concede that there are times when that is an appropriate situation. For example, in Taylor v. Blaylock, the employee actually went through a period of time, he was promised a bonus, and he didn't take salary for 3 months, and he continued to work. But what this court said in Tierney was, if you're only doing what you were supposed to do, and there's not even an allegation that says in the complaint, if you read it, it doesn't say that he agreed to stay because I'll tell you exactly where it is.
But doesn't there amplification in an affidavit in this case? I mean, you're allowed to remedy a defect in a pleading with an affidavit, and here he did remedy that particular defect in the affidavit.
Well, it does say at paragraph 12 of his affidavit, he says boldly that I agreed to stay. That's true, but it doesn't say that he had agreed to take on any new obligations. If there were the case that an employers can say, I'm giving you X, doing a good job.
Are you saying that if an employer offers you a raise sometime during the year, that if you don't take on additional duties, you're not entitled to the raise that was offered to you?
I think in those situations, I mean, every case is somewhat different. I mean,
I don't see why that's
well,
different.
no, I mean, I think that if an employer offers you a raise in the course of the employee. I can't disagree with you in that situation, but there are also, under those circumstances, claims perhaps under the labor law, and there are other remedies. But as a straight matter of contract, where's the consideration? There's no promise.
Well, because the person doesn't leave, they stay.
Well, but on that theory, he could have given him the 75 units, and he could have left the next day. There is no quid pro quo. I mean, that's the flip side of it. If they say to him,
Then the defense would be you breached the contract. Maybe we did have an oral contract, and that for you staying, you get the 75 units, but you left the next day, so you're not entitled, even if there is an oral contract, you're not entitled to it because you didn't stay.
but
You didn't
there's
fulfill your
no,
promise.
but there's nothing in this record where there was a direct quid pro quo. He says that this is why I stayed. It's different that there was an allegation.
Didn't he
that
say that
had a
that's why he
con-
told him he stayed? Like I said to him, I was.
I'll read what it exactly it says. I have it right here. It says it was I sent them the requested signed documents and asked about the written agreement for the 075 points, which were promised in part for my remaining at Patch. Now, I
It
suppose.
specifically says for
Yeah,
my remaining, not just
I-
staying till the next day.
I suppose that if, the difficulty I have is that we do have the Tierney case as interpreted by Taylor, which just says the opposite. What the Tierney case says is that, and then Blaylock described it. He said, the employee purported to do no more than he was already obliged to under the contract, and that was an at-will contract. Yes, we could end up going down the discovery road and see what the promise was, but that's what this court has decided. And in fact, then this court in Taylor distinguished the Tierney case and said it was different because in Tierney, the guy forewent salary. So unless the court, perhaps it wants to overrule Tierney, that's one thing. But that's what the law is in this, in this court.
Thank you.
Very quickly,
What's your response to that's what the law is in tyranny?
when you are, it would completely upend the financial industry in this industry in this city. People are promised compensation when they come, and then they're saying, we're going to give you another $50,000 or another $3,000. And they, in reliance upon that, stay and they perform. We're going to give you a bonus. Consideration doesn't have to be anything more than nominal. And certainly continued employment is more than nominal additional.
But would this overrule our holding in tyranny if we say this?
I don't know to which he refers, but on record at page 108 on our thing, it says it not only continued employment, but additional efforts on behalf of Patch. The bottom line is that employees, the raise is exactly the same thing. If you're promised a raise and then you continue to work, they could turn around and say, well, you would have left anyway, even without the raise. There's not that kind of inquiry into consideration in this context. And there's lots of case law that talks about continued employment. If I'm offering you my continued employment, how can there not be adequate consideration for paying me the money that you promised? There's not an inquiry. We're going to get into litigation about whether he would have left on day 7 if he didn't get the additional consideration. No, promise additional consideration from an employer. And I would add that arbitration provisions are enforceable based on continued employment, which employers want to see enforced. Arbitration provisions, there was litigation. Is it enforceable, an arbitration provision in a contract? It was challenged and said, no, you continue to work there, it's enforceable. What's good for the goose is good for the gander. It should support an arbitration provision, by the way, but it also should support, you promised me this extra equity, you promised me this extra bonus, and I continue to work there. And here he worked for years. If he left the next day, which is, Your Honor, your point, I mean, there's a covenant of good faith and fair dealing that underlies every contract. And it would be fraudulent, to secure an equity and then leave the next day. I mean, obviously, they would have defenses to that. He stayed years here, years after getting that equity. Thank you, Your Honor.
Bacharach versus Board of Managers.
Nicholas P. Yanuzzi, Boyd Richards for the appellant defendant. If it pleases Your Honor, the decision of the motion court must be reversed and the motion granted and the board's motion granted. The governing documents are very clear in this case that the board has discretion in the enforcement of the rules of the condominium.
So under your theory, the board can simply ignore a shareholder's complaint indefinitely, and that's not a violation of the board's obligations?
So in the
At what point does it become a real obligation, or can they just ignore it indefinitely?
The board hears all complaints, but the board also has the discretion to address the complaints, and the business judgment rule strictly or specifically says that the board has the inside knowledge, knows the peculiarity of the building, so not all complaints need be addressed necessarily. So no, the board is not compelled at all times to act on it.
That rule includes a standard of good faith.
Absolutely, it does include a standard of good faith, but not all complaints are created equally. And particularly a complaint in this case, which the court, the motion court, said there was no noise violation, and it also acknowledged that when the board did go in and do an inspection, the apartment upstairs was compliant with the rule. So all plaintiffs' claims, the entire complaint that was made, was proven or was disproven by the court. So in this way, this is the perfect example of not all complaints do need to be addressed because some complaints have...
So you're saying that the trial court's finding that the elements of private nuisance had not been made against the people in 4D means that validates your business judgment?
In this specific instance, it does show that there was no noise violation, but that doesn't... The board's position is that the board has discretion to address complaints that are given to it.
But it also has to, it also has to advance the purposes of the corporation. How did it advance the purposes of the corporation by not going and making an inquiry around the time that the first complaint was made, as opposed to waiting for years?
I'd first suggest that the complaints, the documents that were provided were started in 2019. This issue did begin before that, including a period when Mrs. Bacharach was on the board. And so this, unfortunately, the documentation is what it is, but the addressment, the fact of the matter is there's no mandate in the documents, there's no mandate in the language of the documents that forces the board to act.
What about the finding of the trial court that based on the different provisions of the governing documents, it creates an ambiguity as to whether the board did or did not have a duty to act under the circumstances of the case, that it's not clear from the various provisions that the board has unfettered discretion to not act on a complaint for years?
I would suggest that the motion court's interpretation was incorrect on that point, that in read in concert together, the documents, as I say, are clear. The board has discretion in the enforcement of the rules. All of the provisions read together, the board is given the discretion to evaluate, and there's a presumption that the board does consider the facts and makes the decision based on that. 9.3, which is colloquially the non-waiver provision, makes it that the board doesn't waive its right to enforce the rules at any time just because it hadn't acted.
What about the language, for example, in section 2.4a, that the board shall have all the powers and duties necessary for the administration of the affairs of the condominium, and one of the powers and duties of the board is to enforce by legal means the terms, covenants, and conditions contained in the governing document. Doesn't that create an ambiguity about what the obligation of the board?
No, because that is a discretionary act, because not all complaints, not all violations require the board to commence a legal action. Simply missing maintenance for 1 month
We're not saying a legal action. They didn't take, the allegations didn't take any action to do anything to try to
Between these two provisions, Your Honor, the 15 allows the board to take legal action. 14 allows the board to issue fines, but those are both discretionary that the board could do either one. I believe it's 5.6 that says that the board can act in equity or law. This is discretion, that the board has discretion.
Isn't the allegation here that the board did nothing for years? It took no action and just ignored the
The board has discretion in the enforcement of the rules.
So the discretion is to just not act for multiple years while a complaint is open and ongoing?
In this instance, the board acted in accordance to its judgment. The board acted in
Okay,
accordance.
so then the answer to that question is that the way that you're reading the bylaws is that the board has discretion to not act versus discretion on how to act.
The board does have discretion to not act. Not all complaints are actionable. Not all complaints require actions from the board, yes.
How
Would
do
a
we know
complaint
from
of
this
this
record?
nature?
I'm sorry.
Would a complaint of this nature require, under normal circumstances, board action?
The point of the business judgment rule, and I'm going to answer your question this way, the point of the business judgment rule is that the board knows the community. The board is the best person, the best body to address the complaints. So us in isolation to say, you didn't do anything, how could that be? The board has been dealing with this situation for XYZ amount of times, knows all the players, knows better than us, and that's the point, that we are not to be second-guessing the board's decision and creating a timeline.
Then they can, in essence, apply the bylaws whichever way they see fit. And the unit owners simply have to sit there and take it.
I would say, no, there is a presumption that the board acts in good faith, and unless shown otherwise, which is not shown here.
2 years to act on complaints it's not a presumption that they were not acting in good faith?
Again, the 2 years involved, the board, based on the non-waiver provision, again, there's no timeline here. There's nothing in the issuance.
Isn't there a reasonable time within which, if they are going to act, they should be acting?
Reasonableness is directly rejected by the business judgment rule. So I would say no, there's not a reasonable question. It is the board's discretion, and the board is presumed to act correctly unless shown to have acted in bad faith.
Why doesn't the passage of time at some point constitute some indication, as my colleague said, that the board is no longer acting in good faith? I mean, one thing if they'd written back to the plaintiffs and said, we've investigated your complaint and concluded that there's no merit to it. They did nothing.
Again, this is not for us to second guess because we don't know the nature of the parties. It's easy to, in a vacuum, to say, well, you didn't do anything, but you do not know.
We're not talking about a vacuum. We're talking about no action for 2 years.
Again, but we don't know the natures of the parties, and the corporation is the body in position to know these people more than the court, more than the lawyer who's brought in at the day of the court.
And if the corporation decides these people are a pain in the neck, they can wait as long as they want?
If that is the case, if that can be shown, then that may be a question of bad faith. That may be a question of self-dealing. There are fetters on the board's powers. It's in the bylaws. It's spoken about in the bylaws. There's fetters on the board's powers based in the bylaws. There's fetters based in business judgment, the case laws. But the board does have discretion, and it specifically said that their decisions should be given a presumption of good faith, and that they shouldn't be second guessed by.
Thank you.
Thank you.
Lee Bergstein for the respondents. Your Honors hit the nail on the head here. This is an abject failure by a condominium board to take any action whatsoever over the course of multiple years in the face of viable, good faith complaints regarding very serious issues in the building.
So isn't the board entitled to some presumption in its favor?
Presumption in its favor with respect to?
With respect to acting properly in the interest of the condominium.
Well, the business judgment rule does give the board a presumption. However, and Lewandowski sets forth that if a unit owner comes forth with allegations of illegitimate purpose or bad faith, which is clearly the case here, then the condominium cannot rely on the business judgment rule to defeat the pleadings at the motion to dismiss stage. So what Judge Leibovitz said here is there needs to be a factual inquiry as to whether or not the board in fact acted in bad faith.
It's opening up a Pandora's box in some way, though, if we let these kind of claims go forward, because everybody in New York City complains about the noise above them. Everybody's got running children above them and people walking around and are unhappy. What is the board really supposed to do in that situation, and what's wrong with what they did here? Because it is such a common situation in New York, and do we want the courts to be filled with litigation between neighbors who are disgruntled about some noise above them?
Well, this case is not just about a noise problem between neighbors. Again, it's about the board's abject failure to act, and not just any board. And I know my adversary makes this point in his brief. This might set a bad precedent for other condominiums. This is about this condominium. And this condominium chose in their bylaws to write The powers and duties of the Board of Managers includes the duty to enforce by legal means the terms, covenants, and conditions contained in the condominium documents. It's not just about nuisance. There was allegations of unpermitted work. There was allegations of work that was done without consent. There was allegations of flooring work that was installed antagonistic to what's required by the New York City Department of Buildings. There's allegations of substantial violations of the House rules, including the failure to comply with the 80/20 provision. So in this particular case, I don't think it's opening a Pandora's box that the board took no action over the course of multiple years to investigate repeated violations of both the bylaws and the House rules when there was a very clear duty to act.
Go ahead. Do you have anything else?
No, Your Honor. Thank you.
Okay, thank you.
Just very quickly, Your Honor. Again, it bears repeating that it was not a viable complaint. The court has shown that it's not a viable complaint. So counsel and plaintiffs continue to refer to it as a viable complaint, but it's already been disproven as a not viable complaint, a thing incidental, and that incidental to apartment living. It's the idea of Lewandowski that there are certain freedoms that you give up in living in a community such as a condo or co-op, and that's what this is. It is incidental to New York living. In the complaint, no bad faith is actually claimed. It is simply a matter of the plaintiffs questioning the manner in which the board acted. The plaintiffs acknowledged that a fine was issued. The plaintiffs acknowledged that at a certain point, agreeably in a certain point, the board did start mediating between the two parties. Their complaint is that the board didn't do enough, is that the board should have done more. And that goes, again, to business judgment, because this is a questioning of board action. This is a questioning, a second guessing of what the board is doing. The plaintiffs are complaining that the board didn't do enough to enforce their claim. And the issue about a complaint when it comes to the board is that a complaint involves two separate people that the board must mitigate between. And siding with one is siding against another, and it puts the board in a very treacherous position that opens it up to liabilities and may go against its fiduciary duty.
Thank you.
Thank you, Your Honor.
People versus Govan.
Good afternoon, Your Honor. Your Honors. I'm Catherine Martone on behalf of Mr. Govan. I'd like to address the issue we raised in point 1 of our brief and in our reply brief. That is that the admission of the DNA evidence relating to the rape kit samples violated Mr. Govan's right to confrontation. The testifying analyst in this case, Ms. Hardy, didn't participate in the final step of testing that generated.
Now, you'd concede that the people don't have to call each technician who was involved in the analysis, correct?
I do, Your Honor, yes. And the problem here, under the circumstances here where Ms. Hardy wasn't present at the final stage of testing, the Court of Appeals has recently clarified in People v. Jordan that the prosecution must make a clear record establishing that the testifying analyst and, quote, conducted an independent analysis of the data that was used to develop the profile in a manner that would enable her to replicate the profile or identify any errors in the determination that was made. In this case, it's clear, in Jordan, the record was deficient, where the analyst who testified said that he conducted an independent interpretation of the data contained in the paper file. Here, just as in Jordan, that was Ms. Hardy's testimony. Her only involvement was, and this is at page 523 of the transcript, looking at the data printed out in the case file, going through every single page.
Counsel, what about in the transcript at 506 where she indicates that she looked at every single step of the DNA testing process from exam to generation of the final result and made her own personal independent conclusions and interpretations from the testing and the data that had been generated.
Yes, Judge, and this is exactly the problem in these cases, is that apparently these witnesses are prepared to testify that they conducted an, quote, independent analysis of the data and that the data they analyzed was, quote, raw. But what the Court of Appeals made clear in Jordan is that the conclusory assertion on the part of the witness that her analysis was independent or the data was raw is just not enough.
But isn't that something that can be addressed through cross-examination? If you think it's conclusory and she's trying to pull the wool over your eyes, isn't that something that can be addressed?
I'm sorry, Your Honor, but the answer to that, I am so happy to say, in light of People v. Jordan, is no. It's the prosecution that is required to establish the clear record, and that's the court's language, clear record, that they're calling the proper witness. So the burden is not on the defense to expose the weaknesses in the testimony. But here, counsel really did do that. And we do know from counsel's cross-examination in this case, the ways in which the data that Ms. Hardy reviewed was incomplete. At should I?
You have time rebuttal to finish up. If you just finish the sentence, but.
At page 511 through 512 of the transcript, you will see that Ms. Hardy testifies that the paper file does not contain the RFUs, relative fluorescence units, that are important to developing the profile. That's just one example of the deficiency that counsel's cross-examination did expose in this case, although it was not her burden to do that.
May it please the court, David Gagne for the people. The admission of DNA evidence in this case did not violate the Confrontation Clause because the testifying analyst reviewed every step of the DNA testing process.
Counsel, what about your adversary's argument that that testimony was essentially tailored to meet the burden of what the Court of Appeals has said, but when you really dive into the testimony, there are certain aspects that this analyst did not look at and did not have information about?
So the testifying analyst was very specific that she reviewed every single page of the paper file, and that included all 4 stages of the DNA testing process, including, and she made this very specific, that she reviewed the electropherogram, which is the data that's generated at the final stage of DNA testing when the DNA profile is generated. And my adversary is suggesting that People v. Jordan somehow changed the law. It did not change the law. It simply reaffirmed what the court said in People v. John, which is that the witness must independently analyze the raw data and form their own conclusions from that data. And that's exactly what the witness did in this case.
Well, what about the issue regarding the RFUs and measuring the height of a peak and the testimony relating to that? Was this witness able to testify about that?
Right, so the RFUs are not required to be able to independently verify the accuracy of the profiles. That may be something that in some cases is necessary to go back and look at, but that is not always required. No court has held that the testifying analyst, in order to make her own independent conclusions, has to be able to see what the RFU is. All that does is simply indicate the height of the peak.
But the peak heights are important to DNA analysis, correct?
So the peak height, she said, can be important, but that's not true in every case. And in fact, what this court said just last year in People v. Taylor is that when the analyst reviews the entire paper file and writes her own reports, making conclusions about the DNA profiles, That is an independent analysis of the raw data, and that satisfies the confrontation clause, and that's exactly what happened here. Unless there are any questions, I ask that you affirm. Thank you.
Thank you.
I'd just like to provide one more example from the testimony to show the way in which we know that the data, which the Court of Appeals was clear in Jordan, needs to enable the reviewing analyst who is testifying at trial to replicate the results. So at line 21 of page 524 of the transcript, Ms. Hardy is describing the process in general as to what happens at the final stage. And at line 21, she says if a sample, if there is a number that is or peak is labeled, the analyst is interpreting it based on their training that it's not a true DNA type, then the label is removed. So it doesn't become part of the profile. The electropherogram is a printout of the results of the analysis. As she explains here, that action, when the person viewing the data on the computer screen edits out the information, that it's not, edits out the label, deciding based on the information on the screen, the raw data, that it's not a true DNA type, then that action is documented in the edit sheet to say the size of the label that was removed, as well as what is its color, its location, and what the actual artifact is described as, essentially justifying and documenting why the label was removed. The edit table explains why these labels is the documentation that explains her action in removing the label. So if you look at an electropherogram, you're not going to see any colors. It's a black and white piece of paper in the file. She's saying she's making these decisions based upon the color of what she's seeing on the screen, and this is throughout her testimony, that the color of the images is important. But what you have to rely on in the edit table, which explains her changes to the data that was on the screen, is the interpreting analyst's statement that the label was red, yellow, blue, or green. Ms. Hardy, reviewing this file, has no firsthand knowledge as to whether that was a correct notation as to what she saw on the screen.
Thank you.
Thank you, Your Honor.